particular. And today we've got four fantastic guests who are going to talk on cerebral palsy, the obstetrics crisis in South Africa, what's to be done. Now, we all know that we're in a crisis situation, we've got problems, but what's the way forward? And what we really try to pull together today are people who are thinking forward, who are thinking laterally, and who are coming up with solutions. And we'll explore some of those solutions with them today. So we've got a number of guests. I'd just like to go through and introduce you to the four guests as a start. And the first one is Professor Ismail Bhorat. And Ismail is a well-known figure. I like to refer to Ismail, I'm sure you won't mind this, I call him the Mick Jagger of the medico-legal profession. Everybody can see why that's the case, but he's a real character. You'll get to know him this evening. He's got a lively intellect, and I love interacting with Ismail. And he also has a knack of taking complex concepts and really putting them across in a way that's compelling. And on the screen, I put basically the basic bio sketch for Professor Bhorat. You can go onto the Prec Guide website, and if you go to the show notes and registration section, you'll find all of this information, background information on each of the four presenters today. And you'll also find additional information such as the Better Obs program, how to access that, and information on it, which I'll put on later this evening if anything additional comes on, or it's there already. Hi, Ismail. Nice to see you.
Hi, Ian. Nice to see you as well, and good evening, everybody.
All right. The next one is, let's see if we just have a quick look at Romany Sutherland. Romany, hi. Nice to see you down there in the Western Cape.
How's it, Ian? How are you keeping?
Yeah, not too bad. We're right at the end of the lockdown, so I've got to say it feels like the end of a very long weekend. Feels almost like I'm getting out of school, and we've got school holidays coming up tomorrow. I think everyone's going to be in the beaches in KZN. But great to see you, Romany. Romany's a medical malpractice and insurance lawyer. She's based in Cape Town, as we say. She's 13 years experience as a medical negligence lawyer, predominantly representing the plaintiff. She joined Norton Rose Fulbright in November 2019 as part of the insurance litigation team, focusing on medical law and medical malpractice claims. She advises the Department of Health in the public sector, as well as various insurers in the private health sector. I've known Romany now for some years. She's a very good friend of mine, and I must say I really enjoy interacting with her. She's a sharp mind and a bubbly personality. So we'll get to know Romany a bit better tonight, but not one to be trifled with in any sense of the word. Pity we can't be having a nice glass of your Western Cape wine at the same time, Romany. That's the only problem here.
I agree.
Next up, Johannes van Waart. Hi, Johannes. Good to see you.
Hello, Ian. Good evening, and good evening to your listeners.
Johannes has served as the SASOG president from 2015 to 2018. He was the founder of the SASOG Better Obs program, which we will discuss tonight in a bit of detail. And he currently serves as the SASOG Better Obs national lead obstetrician, along with Dr. Segi Naidu, until 2021. Johannes was elected president of FOSAS, Federation of South African Surgeons, in 2018 and serves a 2-year term. FOSAS represents all 21 surgical disciplines in South Africa and represents approximately 6,000 surgeons. So, Johannes, we're really pleased to have you on the program as well.
Thanks.
And then lastly, we haven't got this up because you sent it through to me fairly recently. But how are you, Stephen? How are you doing?
Good, and you, Ian?
Good to see you. Stephen is a mathematician. He's been an independent broker and risk analyst for 25 years. He focuses on risk management, regulatory reform, healthcare analytics, and developing platforms to support healthcare practitioners and facilities both locally and abroad. So we've got a really great collection of personalities and minds. And I must say one thing is that I'm finding with this program, we're getting together the sharpest medico-legal minds that are out there, and I'm really honoured that each of the guests has agreed to be present tonight. I just want to, before we start with the guests, I just wanted to housekeeping matters. For viewers, please bear in mind that you can ask questions via the chat function or via the Q&A function. Please send your questions in. It's a great opportunity to ask questions of leaders in their fields. And then I will direct those questions to the panelists. We've got a follow-up program on Sunday at 8 o'clock, which is going to be in conversation with Ian Dutton. And what we will do is we'll round up the week's events. So we've had 2 webinars this week. We'll take those webinars. Any questions we couldn't get to, we'll deal with. And we will also have contact with each of the guests who's agreed to be available. So if there are questions coming in that I can't deal with, I call it phone a friend, like we had on Who Wants to Be a Millionaire. And then I can phone whoever it is that's appropriate, and they can help me out of a bit of a tight spot. And we'll have 1 or 2 interviews as well with some interesting personalities, including latest case law and developments within the mediation sector. There have been quite a few developments this week already. So please look out for that. That's on Sunday evening at 7:30. We've decided on that time. So please join us for that and look out for the link to that. All right, without further ado, let's get into the topic. Let's start with Professor Bhorat. Ismail, you in particular are going to talk to us about the expert opinion panel. And I think just to orientate ourselves, let's give us an idea of what the panel is and what its intentions are, please.
Okay, a very good evening to Ian and everybody at home. I firstly want to thank you for inviting me onto this program and all the work that you've been doing. So as you said, I chair the EOP. It's the expert opinion panel. It was constituted originally to deal with the enormous challenges facing ONG at these recent times. And we were initially constituted, right, as a contrast, all right, to what was happening in court with the serial experts and the hired gun experts who were giving singular, maverick, biased opinions. And we, on the other hand, in the EOP, in contrast to that, would endeavor to give neutral, independent, evidence-based, scientific-based opinions. And that is the contrast. And that is our core function in the EOP. But I think a lot of people out there are going to ask, how do we trust the EOP? How do we know that the EOP is going to render this independent and unbiased and whatever I'm speaking about? For me to answer this question, the first thing you got to understand is who sits on the EOP. The EOP, it's only high-level experts that get onto the EOP. It's an honor to be on the EOP. There's certain criteria that have to be fulfilled before you can get onto the EOP. You either have to be a subspecialist, you have to hold a PhD, you've got to have a clinical track record, you've got to be peer acknowledged, etc., etc. And the academic and the intellectual gravitas of the people that sit in the EOP in some way will give you an assurance that the opinion that you're going to get is going to be the real deal. That's the one thing. The second thing is there's no plaintiff or defense that's going to ask an expert to give an opinion. It's the EOP executive that is going to choose the expert. And I always feel that if either the defense or the plaintiff phones for an opinion or asks an expert to give an opinion, I'm not saying in all cases, but there may be an inherent bias with that. Whereas in this particular case, the executive of the EOP is neutral. We don't have anything to gain or lose. We will choose the experts. That's 2. 3, depending on the complexity of the case, we will have up to 3 experts that will look at this case. Now, if 3 experts look at a case and they all are saying the same thing, or it's consistent, that opinion is very, very strong and it will be likely to be unchallenged. 4th, when the opinions are complete, they do not go either to the defense or they do not go into the plaintiff's hands. It comes to the executive of the EOP, where we will then do a quality check on that opinion. So you can see the checks and the balances. And I can tell you, we may not always get it right, but for most instances, I think the opinion you're going to get is going to be the real deal. Now, the vision for the EOP started a few years ago amidst this hopeless realization that the whole litigation thing in obstetrics and gynecology was just getting out of control. It was like a train on a track that was hurtling towards a cliff and nobody can actually pull it back. You know, and the main consequence of that was the insurance premiums of the obstetricians were rising at an unsustainable rate. And the consequence of that was a lot of the private obstetricians were getting worked out of the system. And there was this eerie acceptance of the status quo. But not all of us accepted that. Okay, there was a fight back strategy. And out of that fight back strategy arose 2 fundamental transformational concepts. The first transformational concept was the EOP, as I spoke about. But there's a second important transformational concept as well. And that is, we needed to look at ourselves as well. We needed to do an introspection. We needed to see that we were doing the right things, because we also have to take responsibility. If we are wrong, we should acknowledge that we are wrong, and we should be accountable for that. But by the same token, if there's an adverse event and standard of care was done, we should not be held accountable. So the question you want to ask me is, if you did everything right, why did you get an adverse event? That's a very valid question. The answer to that question is that the field and the space that we work in, where there's obstetrics and gynecology, internal medicine, pediatric surgery, it's not an exact science. I can do exactly the same thing on one patient and get a fantastic outcome. And I can do exactly the same thing on another patient and I can get an adverse outcome. Why? Why is that the case? And this is the understanding that everybody must understand. Because in every clinical scenario and every clinical case, there are what are called variables and confounders. And a classic example is CP. Everybody knows about CP because it's a high quantum case. We'll just talk about CP. Almost every CP case gets defaulted into acute intrapartum hypoxia. And we know from epidemiological studies that only 10 to 14% of all CP cases are actually due to intrapartum hypoxia. There are concepts called fetal priming, which nobody ever speaks about. Fetal priming is a very common fetal problem where babies are hypoxic before they enter into the labor process. Things like late onset RUGR, things like infection. And a lot of these things are subclinical. It means you will not know that these fetuses have the problem before they come into labor. I can tell you, if a fetus is primed with late RUGR or fetal infection, no matter what you do intrapartum, even if your standard of care is 100%, you are going to land up with an adverse outcome. And the poor obstetrician, yeah.
And that I must say that ties in. The law recognizes exactly what you're describing, and that is why you can't simply say that where you have an adverse event that there's been negligence. There isn't. The law recognizes that you can't have that simple correlation between the two for exactly the factors that you're describing. And thank you very much. You've set out the basics of the EOP very well. I think just one point of clarity on the EOP, just for people that maybe have never encountered the concept before, is maybe you can just, to finish, you can just briefly tell us who sits on that panel. Which professions is this? Only obstetricians? Is it designed for obstetrics? Just give us exactly the focal point of the EOP, please.
So sure, Ian. The EOP is an obstetric and gynecological forum. Let me put it that way. So we have a chair, that's myself, so I chair the EOP. We have a gynecological panel that is chaired by none other than Dr. Johannes van Waart. And there's an obstetric panel that's chaired by Professor Priya. So, and then we have a board of directors, there are 6. Underneath the board of directors, we have about 40 high-level experts in each field of obstetrics and gynecology. That's fetal medicine, endoscopy, obstetrics, general gynecology, oncology, and all of that. So that's the basic structure of the EOP.
And Ismail, the idea then of the EOP in summary is so to get a base or a foundation of good experts, of experts that are of quality, and to try to get those experts to feel that they're independent and they can give an independent view, as opposed to feeling that they a bit more pressurized because they've been approached either by plaintiff or defendant.
Correct. Absolutely.
All right, Ismail, thank you very much. I'm going to. I think it's a convenient place then to move next to Dr. Johannes van Waart. Johannes, we've heard about the expert opinion panel, and it's I must say it's one thing that Ismail said that really resonates is the sort of fight back attitude, and you know, the way he so graphically described what's happening as a train hurtling down tracks towards a cliff. And you know, one of the reasons we're looking at and trying to give some publicity to what's happening insofar as these initiatives is concerned, is because it's creative thinking, and we're tackling the problem. And the other aspect that I'd like to speak about, Johannes, and if you can talk about this for a few minutes to us, please, is the Better Obs program and what that is and what it's designed to achieve within the context of the medical malpractice crisis.
And thank you very much. Yes, so just a little bit of background. In 2015, we actually sat down and we saw there's a crisis coming because insurance premiums were rising from initially about 200,000 Rand a year to within a short space of time of 7 years to more than R1 million a year. So the problem that we have is that it's becoming unaffordable to practice obstetrics because the medical aid rate is just about 5,000 Rand per delivery. So we had to stratify and do something to improve this. Now, we were playing the blame game before that time, and then at a certain point in time, I realized that we're going to have to look at ourselves and say, what can we do? We cannot control the lawyers, we cannot control the law, we cannot control the insurers. So we came up with a plan which is the Better Ops program. And what that is that we wanted to up our game to levels that we have standardized models to work in. And there are 4 pillars to this. And as you can see on the screen, the first and probably the most important pillar is the obstetricians. So at that point in time, whatever university you trained at would have a little bit of a different way of looking at certain things. And what we wanted to do is standardization, because it not only makes sure that we all do the same thing under the same circumstances, but it's also much easier to defend if something goes wrong. So what we've instituted is some guidelines that all people or all obstetricians should adhere to if you have a specific life-threatening event, like somebody's having a lot of bleeding or there's a certain adverse event coming up, that you have standardized protocols. The second thing, we had to review them. And at that point in time, everybody were doing their own things because remember, we're specialists and there's nobody as clever as a clever specialist, we thought. And obviously we were wrong. So we started with maternal mortality and morbidity meetings, which were held every second month, where we look at adverse outcomes or near misses, as we would call it. So things where things just went right, but it was fortunate. And then we reevaluate, and then we see what can we learn from that. And these meetings include the obstetricians, the nursing staff, and also the pediatricians, so that we can form a team. And then we were not very good at keeping notes. And then 3 years down the line, if you get an adverse event or you get a lawyer's letter, you can't really recall what happened. And that's really, you put yourself out there. So now we have to have standardized delivery reports, which uses all the different time points. And if it's a complicated delivery, it has to be in more detail. And then the last thing, we had to inform our patients that we have this program and that we would do our level best to make sure of a good outcome. The second leg of this would be the pediatricians, and we're very dependent on that, because sometimes you get the babies, you have a good delivery, the mom might go home and the baby might fall off the chair, get a knock on the head, and they get in some kind of a convulsion, and all of a sudden everybody points the fingers at the delivery process, which might not have gone as smoothly. They must also attend the maternal mortality and morbidity meetings, and they're there to give their own discharge summary and give a prognosis on the delivery. The hospital is the third part, and we had all hospital groups buying into this concept. And what they must do is also not only make the patients aware, but make sure that their staff in the labor wards are well informed and well trained on the emergency processes. And then through the hospital, they're also supposed to support the doctors to make sure the M&M meetings take place in each and every hospital. And then the last pillar was the patient, where the patients actually must know about this incentive, and that they should buy into this and make sure what the risks are, and certainly also should buy into the concept. Now, in order to do that, we had to go through quite a lot of admin, and in each and every private hospital in this country now, there's a lead obstetrician, which guides this process in that hospital. We have 6 regions we are divided into, with a regional lead obstetrician, and that's Gauteng North, Gauteng South, Western Cape, KZN, Eastern Cape, and the Free State. And then you also have national lead obstetricians and a Better Ops management committee that guides this process. So this is basically the process. We've got guidelines that's coming on fast and furious, and I think in the next year or two, we'll have guidelines out there for each and every condition in pregnancy and standardized guidelines, which we would put out there for obstetricians to adhere to. Part of the Better Ops program is also the expert opinion panel. Then the last two concepts is what we've brought on now is firstly that with each and every complicated delivery or all normal deliveries, and remember 95% of all the cases against us come from complications from normal deliveries. Now you do a umbilical cord pH, and if that is satisfying, in other words, it's good, then it cannot be an intrapartum event. So even if the outcome might be bad, it probably points to something that happens in the antenatal course, and it's not the fault of the obstetrician, and very often before, we've been held responsible of that by the legal profession. And the last part of this is the cerebral palsy document that Ismail is completing at the moment, where we would try to make people out there, and especially the legal profession, aware that pre-priming and 85% of all cerebral palsy cases has absolutely nothing to do with intrapartum negligence or negligence during the delivery. So in short, that's the Better Ops program. There is documentation coming out on that. This is the basic ones that you have. And certainly, I mean, in the Q&A part, we can answer questions if there are anything about that. But I think we've upped our game, but we need the legal profession to buy into this as well, because we have to get a sustainable model to deliver babies in our country. Thanks, Ian.
Thank you very much, Johannes. And there are 2 points, and we can pick up on this in the second half of the program. But there are 2 points that occurred to me that of what you've just said, which I think are of particular importance. And maybe I should just highlight them now, and we can come back and talk about them in a bit of detail a bit later. The first was your point about practitioners taking notes and proper notes, and that has become, in my view, even more important than ever in the light of a recent Supreme Court of Appeal decision, in terms of which the Supreme Court of Appeal held that if you can't identify the cause of the injury, then the doctor is the one that has to explain it. If the doctor can't explain that, then it's going to be held to be negligent if that can't be explained away. So that's the first thing, and that is quite an important shift in emphasis which has come from the Supreme Court of Appeal, and it certainly points to doctors needing to take more careful notes about what happened and why, if there are any adverse events. So that's the first message that I think I'd really like to get out there, because that means that note-taking becomes even more important. And then the second point in which we can develop it, but let's just touch on it now, is the question of guidelines. And you mentioned that the guidelines are going to be coming out in the near future, it sounds like to me. And Ismail, I know, is working on an important document as well. From the legal practitioner's perspective, that type of information is incredibly useful, because it gives us an objective criterion that you can then build a case around. And it also gives an assessment, which, so it's an easy way to assess whether there's been compliance or not. And the courts accept these guidelines. They've been accepted for many years in South Africa as a very good yardstick of whether the reasonable practitioner standard has been complied with or not, and therefore whether there's negligence or not. So that's also an important point that came out, Johannes. So thank you very much, and we can certainly explore that later on in the program.
Thank you.
I'd like to then turn to Stephen Kellerman. Stephen, hi. How are you doing? Good. Stephen, from the indemnifier's perspective, you're acquainted with the Better Ops and the expert program and the expert opinion panel. Maybe you can give us a perspective from your vantage point. Let's start off with the expert opinion panel and what Ismail said. Any comments that you make from the indemnifier's perspective?
I think any risk management process, whether it's run by an insurer who needs to understand their exposure to risk and how they can potentially help their insureds, the policyholders, in this case being the practitioners or the private hospitals, it turns on the sharing of information. It turns on an understanding of the mechanisms in the market that exist for mitigating risk exposure, the programs that are there that are educational, that will better inform future performance, support structures, whether it be the purchase of equipment, whether it's basic CPD programs, nurses being able to use technology better. It's quite a complex mechanism, a lot of moving parts, and we all need to be able to use forums like this to communicate, so that with that sharing of information, we're able to identify the things that are key to improving outcomes, like Johannes was referring to, especially in this case, reducing maternal mortality and damage to babies. That's where our large claims sit, the large exposure. It's a small number of events with a large quantum can have a big financial impact on a market. And that can have catastrophic impact, either restricting practitioners entering a particular sphere, or for the delivery of healthcare down the line. If you were, for example, in the South African government context, where you have a lot of CP cases that you can't necessarily understand or manage because of that lack of programs like this that can tell us what's going wrong and how to manage it better.
And then, Stephen, if we turn then to let's get your views on the Better Ops program. You've heard, from a legal point of view, it's so helpful to have that type of objective criterion, and it's something that the court. Remember, the court is dealing with events that the judges aren't trained in or experienced in firsthand, so they're always relying on expert evidence to guide them as to what the appropriate standard should be. So where you have an objective yardstick and objective criterion, certainly from the legal practitioner's perspective, that becomes particularly compelling and convincing in court. From the indemnifier's perspective, can you comment on the Better Ops program and how that plays out in your field?
I can comment from the perspective of working with the gynae management group for 10 years to specifically get the right metrics so that we could understand the patterns of behavior that would then better inform things like the Better Ops program. I think and Johannes, forgive me, I'm going to paraphrase slightly, that in our Better Ops is that it should be the minimum standard that every obstetrician in this country should follow, whether they're in the private sector or the public sector. It's a fantastic method to be able to say, in a South African context, whether it's cultural, whether it's language, whether it's the equipment to which we had access in the South African facilities being, states and private sector being different, that to have a single minimum entry point, because we don't only have South African practitioners here. We have practitioners from all over the world, from different medical schools. We don't all speak the same language or have the same approach to certain things. Better Ops creates that sort of golden thread in every South African environment that brings everybody together in agreement for a single objective, which is improved outcomes. Without intervention like that, you can't possibly expect nurses to understand every doctor's wishes and approach to something. You can't expect patients to understand language that is not homogeneous when they're dealing with different practitioners, and so forth. So I commend Better Ops. I think it's been fantastic work and a long time coming, and we'll continue to support it.
Thank you very much, Stephen. And I think this is a good time then to bring in Romany. Romany, you've heard what the other three presenters have had to say. Let's maybe just start with some general observations on Better Ops and the EOP from your side.
Thanks, Ian. Yeah. I really wanted to commend the Better Ops program and the EOP. I think it's fantastic, Johannes, that you guys looked at the picture and said, well, this is happening. the legal teams are, or the lawyers are going, you know, gung-ho, and they're doing their thing and saying, well, what can we do to change the way, you know, the progression of this? So I've been very lucky. I've been chatting to both you guys for a couple of years now and following you in this process, and it really has been great. I think, as you said earlier, it's important that the legal team start getting on board as well. And you know, we've had seminars together where the doctors and the lawyers come together and they start trying to understand each other's realms, which is always interesting. But we're getting there. We're getting closer. And the one thing the EOP does for us, and when I say us, I'm talking about medical negligence attorneys, is it assists in what is probably the most difficult thing, and that is finding a good expert. It is incredibly difficult. I find that you get attorneys that have based their expert or given an expert report that is based purely on a mother's recollection of events, and that maybe happened sometimes 15, sometimes even 18 years ago. And it's very, very worrying that there are experts out there that are giving reports on just that and nothing else, because there's no records, there's no maternity care record, there's no antenatal records. And that brings me to one of the most important aspects, is obtaining records, the antenatal records, providing those with the maternity care record and the neonatal records to your expert. And I'm a great believer, and Stephen Kellerman and I have chatted about this ad nauseum, in both parties making sure that they have the same information. Let's not, you know, this is a very, very complex part of personal injury law. And as far as I'm concerned, you can't hold all your cards close to your chest when it comes to medical records as well as facts. We need as many facts as we can get in these cases. And when you have that, there's no reason to have two different experts or an expert for each side. I really like the idea of, and we've tried it, we've piloted it. When I was a plaintiff's attorney, Ismail, we discussed this, and my opponent and I agreed that we were going to get all the records. We agreed on that we had all the records. We then drafted a joint instruction to the EOP. We sent that to you, you evaluated it, and you appointed the three experts or the two experts that you thought would be appropriate. And we eventually received a report signed off by you, and it set everything out very, very clearly. It looked at negligence as well as causation. From that point, we could jointly agree that we needed perhaps a radiologist or a neonatologist to assist us further in the causation aspect, but it worked very well. It saved both parties time and money. And I really think, Steve, you said just now about sharing information, that the lawyers need to learn to do that, which is very difficult because, you know, we like a good strategy. But when it comes to getting the medical facts, I think it's vital.
And Romany, you know, I must just endorse everything you say. You know, it's absolutely critical, and particularly the way that we deal with experts. But one thing that I wanted to pick up on with you is this question of shifting from an adversarial approach to a more conciliatory one in dispute resolution, with particular reference to costs and time taken to resolve disputes being curtailed. And you also say with more focus on obtaining all facts available to assess the case, EBM, evidence-based medicine. What, in particular, we've seen in the last few weeks, literally, a shift in the legal landscape from an adversarial litigation-based approach. We've firstly seen the introduction of Rule 41A, which introduces mediation as a compulsory consideration before embarking on litigation. So the parties need to consider mediation. And then we've also seen over the last few weeks with this lockdown, we've seen the possibility of online mediation coming to the fore. And I must say, I can sense for the first time a real ground sort of swell of movement, not necessarily away from litigation as such, but to a multi-tiered approach where litigators start realizing that there's more in their armory than just going the sort of the knee-jerk litigation route. There will be cases that need to be litigated. There will always be so. But I'm starting to sense now an approach where the alternatives of mediation and even arbitration are coming more and more to light. And maybe you can comment on those observations.
Yes, that's definitely the case. And for the last sort of 3 years, when people started doing the mediation courses and becoming mediators, we didn't really know whether this was ever going to pan out. But with the introduction of Rule 41, and as you say, judges sending emails saying, listen, guys, if you're keen, I'm willing to do this trial or this this motion, via Zoom, etc. It's definitely progressive, which is what we've been waiting for. But with that, we also, cerebral palsy, the law around it, the medicine, the science, both, it's the most difficult sort of part of both spheres, the law and the causation, as well as the science. And we were at, Ismail, you were a speaker at one of the events where, the cerebral palsy events, where at the end of the day, we had lots of lawyers that really know what they're doing in this field, and lots of experts who really know what they're doing in this field. And at the end of the day, we both parties looked at each other and said, well, I think we're dealing with probably the most difficult thing that we can in both spheres. So it's the science. And science is black and white. And we say to our experts, give us an opinion on this, and they need to kind of hone in on the negligence. And then you have the lawyers that have to see the whole case, sort of have to stand back a little bit and look at the case holistically. And how I feel it is you have the sliding scale where, the scientists, the doctors are saying it's either that or it's either that, and the attorneys are in the middle, and they're trying to literally, slide this between using a balance of probability to which way, we're going. So it's quite difficult to mix those two. But to get back to your question, if we have a mediation scenario where you have the two parties in a room and you have honed in on what the facts are, the antenatal facts, if there was an infection, as you said, but then you also have, and this is a big thing that we're missing, that the doctors, as Johannes was saying, are going to start focusing on. We also have the cord pH and the placenta that's been tested, where you can see, hang on a second, there is infection. There's proof now that there's infection. With the more facts there are, the easier all of our jobs are. Yeah. So I'm very excited that that's going to happen. Sorry.
Thanks.
Yeah,
I think let's get Ismail's response to that, Ismail. And while you respond, I think Romany made a couple of telling points. In particular, feel free to comment on any aspect of what she said. But I'd like you also to sort of home in on this concept of mediation and a more conciliatory approach. And I'm quite interested to hear your thoughts on how you see the expert opinion panel dovetailing with mediation and a more conciliatory, constructive approach between the parties.
Okay, so I first want to respond a little bit to what you said, Romany, in terms of CP. Now, there are two sort of criteria that can really implicate acute intrapartum hypoxia and CP. One is a cord pH, and the second one is an MRI that's done less than 3 weeks after the baby is born. In most cases in South Africa, those two are not available. Okay, so now we have to depend on other things. Now, in the paper that we've actually done, there's 10 criteria that we're going to look at in every single case of CP. And if most of those criteria are fulfilled, that's in the absence of a cord pH and an MRI, then the likelihood of this being an intrapartum hypoxic case will increase. And the less criteria that are fulfilled, then it's unlikely that it was intrapartum hypoxia. Now, this is a scientific debate. So this is a scientific debate. This is not a legal debate, because you can't. CP is a complex medical condition that deals with fetal pre-priming, with a whole lot of other stuff, with failure of autoregulatory neural mechanisms, with abnormal metabolic pathways, and a whole complex situation. And to get causation is not the easiest thing in the world to get, but that's a scientific debate. What is happening now in the court of law is that the people look at two things only: a CTG and a late MRI, an MRI that's done years down the line. In the absence of anything else, there's no clinical context that's given to either the CTG or the MRI. And remember, the CTG is a temporal reconstruction of an adverse event retrospectively. So if I give a CTG to an expert where he already knows what the outcome is, he's going to look at that CTG very differently if I give it to him prospectively and tell him, you don't know what the outcome is, what do you think? So what we've done with the CP paper is given criteria on the CTGs. What is it that you need to look out in a CTG? Don't tell me if you had an early variable deceleration for a minute somewhere down the line that actually caused the CP. That doesn't work like that. There's certain specific criteria on CTGs that you can look out for that will increase the likelihood that there was an intrapartum hypoxia issue. Now, if all cases had an umbilical cord pH, that would be easy. Then we would know if the pH is normal, it's not intrapartum hypoxia, and if it is normal, it is. So, but we don't have that. So, therefore, we are very for a mediation process, because what happens in a mediation process and alternate dispute resolution, it's a less adversarial kind of scene. And what we would like in the EOP is to get a joint brief. And the reason why we would like a joint brief is that we have high-level experts then can do a logjam break in a sense. We don't have an unlimited capacity of high-level experts. So use us as best as you can. So a joint brief of both the plaintiff and the defense and say, okay, the EOP, you look at this case with your 2 or 3 experts. You all scientifically analyze what you think is the most likely scientific explanation for causation. And then you let us know that. And the 3 experts would look at it. If there's consensus between the 3 with the chair and we give it to you, then that is the real thing.
So Ismail, if I take a hypothetical situation, which is fast becoming a reality, it seems, on the ground. If we are dealing with in a mediated context, and part of an important component of the information which the mediator would need to know is questions of negligence and causation. Now they may not frame it that way, but they need to understand ultimately. There needs to be an assessment, or at least some understanding of the probabilities of that happening. The mediator then could approach the EOP, the expert opinion panel, and who would just explain how that channel would work. So in practice, what would happen? The mediator needs that sort of opinion. How do they go about getting that opinion?
They can contact me directly, right? Or the CEO of the EOP, and that's James Shaw. So we have a CEO who does the day-to-day workings of the EOP. Or he handles all the emails and telephone calls, and I don't have the time to do all of that. So it normally goes through to him. He case logs it on whatever he does, and then he sends the case over to the executive, depending on whether it's an obstetric case or a gynecological case. So if it's a CP case, it will come to me. I will then do an initial assessment of that case, right? And see what is required and what isn't required. If all the notes are available, we need all the documentation, etc., etc. And when we are happy to take over the case, then we will appoint maybe 1 or 2 or 3 experts, depending on how complex that case is. So you can contact either me directly, or you can contact James Shaw, and we can put his email up. He'll be quite happy for us to use it. And that's the normal way it is working at the moment. All
right, thank you. And then from there, what happens? If it's such a fairly serious matter, what channel will you then follow?
So what happens is that If you want an opinion, there's certain criteria that you've got to fulfill, right? To say, okay, we want an opinion, we will tell you, you'll get the opinion within 4 to 6 weeks. It shouldn't be a case that's going to go to court next week. And often we get that somebody wants an opinion in the court and the case is going to court like in a few days. So we can't do that. We need adequate time, etc., etc. And we need notes. We need data. I can't give an opinion if I don't have data. So often that's where we get stuck. They don't have case notes, they don't have the CTG, they don't have this, they don't have that. It's very, very difficult to give an opinion. So generally what I would do, I would first look and see that we've got all the data, because I cannot give you an opinion if I don't have all the facts. If I'm quite happy that all the data has been accrued, then I say, okay, this is fine. I would have done an initial assessment of that case and say, okay, this is a highly complex case. So now I've got to appoint maybe 2 or 3 experts. And then I will appoint those experts and give them 4 to 6 weeks to come with an opinion. At the end of the time, those opinions will come to us. If there's consensus, that means each of the 3 experts are saying the same thing, all right? Then I will look at it, and if I'm quite happy with that, then it would get signed off and get sent off. So it's not sent from the expert to either the plaintiff or the defendant or to the mediator. It will be sent by the chair or the respective chair panel to whoever wants it, to the requesting party. If there's no consent, if there is not a consensus between the 3, then we will have a discussion between the 3 experts and see where the disagreement is. But this is now a scientific disagreement. It's got nothing to do with defense and plaintiffs, because now we are experts, high-level experts, that are now discussing the case. But I can tell you what, to be honest with you, in most cases, right, with the level of experts we have and the criteria that we use, is not, I won't say it's straightforward, but in most cases you will get consensus. There may be differences here and there, but in most cases you will get consensus.
Ismail, thank you. I mean, I don't want to get into this debate now, but I think that to my mind, much of that sounds interesting and sounds workable. My response to it is that I would like, if I was a mediator, or if I was one of the parties, if there wasn't consensus amongst the experts, I would like to know that. And I wouldn't like to feel, being frank with you, that there'd been some sort of filtering of that and the getting together stage that we may have to talk about a bit more and think through a bit more and see how it works in practice.
Can I just respond to that, Ian? So we haven't had a case like that at the moment where we didn't have consensus. So what would happen in a case where someone feels strongly? So for example, if somebody disagrees with something and he strongly disagrees with it, then that person will write a minority report. Right. Similar to what happens in a constitutional court or whatever. Yes. Yes. Those opinions, so a minority report would be written and say, I disagree with the other 2 experts or whatever. So this is a transparent process. We don't have anything to gain or lose with this thing. Let me just be clear. So the EOP is there for the truth. So if in the event there's 2 experts that feel strongly about something and the other expert doesn't, he then has to scientifically explain to us. You cannot disagree without the science. So if you disagree with it, like would happen anywhere else, if you have a disagreement, if the disagreement cannot be sorted out on a scientific argument, then each one would have to write their own expert opinion and submit that. But if that disagreement is based on a scientific fact that can be sorted out and say, but hold it, there's been a paper that was published here that he wasn't aware of, or there was a case that was done and there's a new reasoning or a formulation on how that pathway went, and there's an enzyme here that did this or did that, and says, okay, sorry, I wasn't aware of it. When was that published? That is what I'm talking about. It's not a disagreement. It's not an emotional disagreement. It's a scientific disagreement. All scientists will disagree on cases. If I give you a clinical case and there are 4 consultants that are around it, each of the 4 consultants are going to come with a different diagnosis. At the end of the day, we have to treat the patient with 1 diagnosis. This is common knowledge in all medical fields. So we then sit and say, okay, what's the most likely diagnosis? And then the treatment will be done in that way. If someone feels strongly about it, then of course we will have that discussion. But it's important if you want the truth and you want the science to debate it, is that we as scientists debate it. It shouldn't be debated by attorneys and lawyers and people that are not aware of what is going on, because there is going to be disagreement on a lot of causation. Is not easy.
Yeah. You know, if I may, Ian.
Sure.
You know, I unfortunately, I do think, Ismail, that sort of there are going to be those cases where you have a partogram that's hardly been, there's no CTG machine in the hospital. There's partograms been, you know, crossed the alert line and maybe the action line. And then you do have that MRI that's been done 5 years later and there's a mixed pattern. Or, you know, there's, so the information that you're going to get is never going to be 100% great. Here's everything I need in order to make a clear decision. I've got science to back me up on. And, you know, that's unfortunately the decisions that we've been asked to make. We need both parties, and this is what I hope we can get, you know, to, is where the plaintiff's attorneys and the defendant's attorney get together. They realize they actually both want the same thing, which is the facts. They want the facts. They want to know where they lie in terms of risk. And if that person, if there was an adverse event, if it could have been prevented and that person deserves compensation, yes, let's both together work out that reasonable compensation. But I must disagree with you in saying that it's 100% a scientific argument, these CP cases. You know, I think with all the information, yes, it would be then, but we are very, very seldom presented with matters like that. And unfortunately, the balance of probability does have to come in with regards, you know, and as opposed to the black and white, that is science, that is medicine.
You see,
Ismail, just before you answer, can I maybe just bring Johannes in on this as well? Let's get Johannes's view on this.
Yes, Ian, I think one or two things that's underpinning this is initially when the mandate was given to Ismail to start the EOP, which he's done very well, is the clear instruction was this is not supposed to be biased. So this is not for protecting doctors. That's not the whole reason for that. And I think he stated that, but I just want to reiterate that. This is about fairness. Because if we have an adverse outcome, everybody loses. It's not, I think in a court of law, you have a winner and you have a loser. If we have an adverse outcome, everybody loses. The doctors lose, the patient lose, and I think that's something that we try not to get. So that's why we must up our game as good as we can. But at the moment, what happens, I think if the probability of the evidence is not there and you cannot prove that you've been 100% adequate with a delivery, then it says, well, you are negligent. And I think that's a little bit unfair towards the doctor. So, because there are many deliveries where you get stuck in traffic, you don't get to the hospital at time, you're not there for delivery, and the midwife actually delivers the baby, and the baby is doing in 99.9% cases, the baby is actually doing fine. Now you get a CP case and the doctor is 5 minutes late, all of a sudden you're negligent because you weren't there on time. You should have anticipated that. And I think that's not that clear as far as that is concerned. And that's why I think the work that Ismail is doing in making people aware that CP cases are not straightforward, I think is very, very important. So what we want is we want fairness. So that if there's not enough evidence to make a clear conclusion, it must be stated in a report like that. And I think that's what Ismail and the committee EOP will say. We don't have enough evidence to say that there was negligence, but we don't have enough evidence also to say there's no negligence. So, and those are the cases that ideally would be suited for mediation, because you get patients that don't attend their antenatal visits. They don't know what's going on with the baby. They come in labor into the hospital, especially in the state facilities. And then the nurse, the midwife might not be there to just check it because she has 3 or 4 or 5 or 10 other patients in labor. And then there's an adverse outcome. And all of a sudden, the state is held responsible for the obstetrician. But the mother never attended her antenatal visits. And then nobody says something about that, because clearly from the CTG, there's some expert who would say this is clearly negligence. And I think that's the point that Ismail tried to make. It's not as clear-cut as that. And I think that's where mediation and alternative dispute resolution does have such a strong case to play, that there can be fairness, but that people, if they're negligent, or at least they get compensated to the position where they can use that money to help them in their dire situation, but it's not necessarily negligence.
And Johannes, can I just add to that and then also link that to an earlier point that I made? You know, I mentioned that Supreme Court of Appeal case, and in fact, what happened in that case, and it's very interesting, is that case went in, and you've got a visitor over your shoulder there, Johannes. So we joined. We've got another audience member. During the lockdown, these things happen, but at least my dogs have stopped barking. But anyway, so what happened in that case, and it's very interesting, is that it actually went through 3 courts. So in the first court, there was one judge that found that there was no negligence. The next court up, there were 3 judges that found that there was no negligence. And the next court up, the Supreme Court of Appeal, there were 2 judges that found that there was no negligence. And if my maths, and yes, Stephen is going to pick me out if I get this wrong, but to my maths, that's six judges that found that there was no negligence. But in the Supreme Court of Appeal, of the 5 judges, 2 found there was no negligence and 3 found there was. So at the highest level court, 2 out of 5 found there wasn't negligence, and only 3 judges of all the judges that heard that case found that there was in fact negligence. And that means that if you look at all the judges together and that whole process of the case going through the courts, 6 judges in total found that there was no negligence, and 3 judges found that there was negligence. But because it is 3 out of 5 in the highest court, ultimately that was the last word. And so they found there was negligence. Now, what is and the point that I make there, and actually the finding turned on a very fine technical distinction from a legal perspective. And my view on that particular case is a very sad case, because there was no attempt at mediation. I'm given to understand that the doctor in that case was a dedicated practitioner who'd been working in public service for many years, and imagine the effect of this on that practitioner. And my view is that was a case that was absolutely ripe for mediation, because these fine distinctions, you know, in court, the reality is that on the smallest bit of evidence, a court case can turn, and the whole outcome can turn on something which is completely unpredictable. And my view is that it's far better to get the parties into a mediated type of space where we can look at needs, and we can and the outcome isn't so dependent sometimes on, quite frankly, the luck of the draw. And I'm not saying that's the whole legal system, but I'm saying that particularly in clinical negligence cases, where as Romany quite rightly says, you know, it's probably the most complicated area of law. There are 1 or 2 other areas that might rival it, but as far as the facts and the law are concerned, it's complicated. And so to get down that kind of almost that risk rate, it seems to me that mediation is absolutely suited to this type of matter. And I just want to pick up on a question that Paul Dalmeyer has sent through. He's got a number of questions for Sunday evening when we will revisit these issues. But I just want to just pick up on his question. He says he wants to ask the panel, why did we need Rule 41A to steer the law into the direction of negotiated dispute resolution? This is what is so needed, we all believe in. And I don't know if anyone wants to field that question. I'll just throw it open to the floor. Stephen, maybe you want to make a comment on that?
Yes, I think what's very important before someone technical answers that from a legal perspective is just to understand what Ismail has been saying, and, you know, supported by Johannes, is there are 2 different things that we're looking at here. You know, our experience in the private hospitals is it takes 5 to 8 years from incident date, so cause of harm, date of harm, to settlement date. That's a significant period. What we're dealing with here is better obs is new, EOP is new. You've got a backlog of cases. Look at the state reserving on cases that they've got that are outstanding. That's significant history. A process like Better OBS that establishes a particular standard and that can immediately identify if people have deviated from acceptable clinical performance. Not perfect, because it's not an exact science, but acceptable clinical performance. Not necessarily legal liability, but acceptable performance. And there's an immediate intervention. What we'd want to see in the market practically, and Ismail said it, and Romany said it as well, with you want to go back and look at the past, and you want to start guessing to fill the gaps. Sure, that's a particular section of what has to be addressed and cases that have to be resolved. And a lot of that, you know, a lot of those matters are ending up in court or being resolved on the courthouse steps. And there isn't a real opportunity for this mediation when it's fresh in everybody's mind, where there is the right information. What would be practical is for the healthcare, whether it's the providers, the funders, the insurers, to come together and to say where there is a deviation in performance from, for example, the Better OBS standard, that EOP is triggered, the EOP opinion is triggered early enough so that we have appropriate information while we can still get the information. And that is to everybody's advantage. Part of the problem that, you know, forced Rule 41 in practical terms is that the costs weren't managed. The process wasn't managed. It's a runaway sort of, let's call it a free-for-all. And unfortunately, that drives up costs for the entire market because things aren't appropriately addressed. Just identifying that there's a problem and being able to settle, you know, a matter down the line for significant reimbursement, significant damages, also doesn't help us identify what caused the harm. That's the point of Better OBS to a large extent. Create a standard and hold everybody to account to that standard. And we've got, I think Johannes, I can't think of a single practitioner who said, you know what, I'm not interested in this at all. Yes, they might not like one or two technical tweaks or points about it, but you've created the minimum standard to which everybody is now willing to comply. And I think the important thing is to get EOP to come in frequently enough so that we don't end up waiting years to identify the source of the problem, years before there's interventional correction in behavior and runaway costs that are just detrimental to everybody.
All right, thank you, Stephen. I think that's it's amazing how time flies when we have these discussions. I mean, we're already up on our time. We're slightly over, but you know, to me, we've touched on some of the key points, and you know, it feels to me as if we barely sort of scratched the surface. Stephen, one thing that I must say I very much endorse in what you've just said is you know, an early attempt at resolution, and I speak now from the perspective of a legal practitioner, really helps because that's where you can get the facts, that's when you can assemble the evidence, and it's a nightmare scenario, you know, when you're trying 10 years down the line to reconstitute what had happened a decade before. So that becomes very difficult. So I very much agree with that, Stephen. Just to remind people, we're going to close now, but to remind viewers who've got questions, I know there are already questions lined up for Sunday. Let's deal with the questions on Sunday. I like the idea of being able to contact the panelists. They'll all be available if there are particular questions. Just before we close, can you please, to the viewers, would you please just complete the poll that's coming up? We'd like to make sure that these webinars are focused and that they're at times, as you can see, that suit you. Although I must also just remind everybody that there is a YouTube channel which can be accessed via the website. The web address is behind me, and if you one of the main features on that homepage is access to the YouTube channel. Go onto the YouTube channel and click subscribe, because when you subscribe, you'll get an automatic update on all the webinars that come out. But you can go to that webinar and watch it at your convenience. So these are the poll questions, and if you can just take a minute or two to complete those poll questions, it'll help us to give a product that is broadcast at a time that suits you and at the same time has the content which you'll find interesting. So we'd appreciate you finishing that. And then just in closing, I would just like to thank all the panelists for their time. We're so privileged to have the range of experience and learning and insight that we have from different disciplines. And the whole idea behind this whole initiative is to get people talking, because I firmly believe that in the crisis that we do find ourselves in, the best way out of that is to be talking to each other and to be innovating and to be thinking. And I think that came through very clearly in this evening's performance. So thank you to everybody that's taken the time to watch this this webinar. Thank you to the panelists, and we hope to see you on Sunday evening at 7:30 to pick up on those questions and to continue the conversation. Thank you very much.
Thanks, Ian.